The first couple things that are problematic about the law, I would focus on those because those are the ways that I think your organization should start to think about the law. And so it has a lot of definitions that are left up to interpretation. So I've been practicing fair lending for a long time, over a decade, and there's a term in there in the act where they say you cannot commit unlawful discrimination, and it focuses on algorithmic discrimination. The issue with that is that the term unlawful discrimination is undefined. And if you look in the Equal Credit Opportunity Act or the Fair Housing Act or Civil Rights Act, they don't set a specific standard for what constitutes unlawful discrimination. Similarly, disparate impact is not defined. So you have this kind of dichotomy where the federal government in the White House is saying disparate impact is not a viable legal theory. And you have these states coming out and saying, okay, we're going to focus on algorithmic discrimination, which beyond intentional discrimination must mean disparate impact. But then there's no standard for what constitutes disparate impact, right? So you can measure disparate impact in various ways, like through adverse impact ratios or SMDs, but there's no set threshold for what is disparate impact or what is unlawful discrimination. So I think that's something that you should talk to your legal team about. How are we as an organization going to define this term of disparate impact or unlawful discrimination? And I don't have the answer here for you. That's something you and your organization would need to come to an agreement on. What is a consequential decision? So the act, in order to comply with all of the different requirements, such as doing an impact assessment, doing documentation, giving notices and disclosures, before you take on all those obligations, you need to determine whether the particular AI system meets the definition of a high-risk AI system, which is one that makes a consequential decision. Okay, so at Upstart, we would then say, well, clearly like an underwriting model is a consequential decision because it's providing lending services. But what about a verification model? Is that a consequential decision? Is that determining whether someone gets a loan? What about marketing? When you market to different segments, does that determine whether someone gets a loan? What about servicing? So those are things at your organization you need to sit. And again, this is not just a lending law, to Bart's point. This is
Yeah.
for any high risk AI system in healthcare, in employment, in housing, in all these different sectors, which is why AI Guardian is needed for a lot of people that don't know what we're talking about.
I can't even tell you how many previous proposed state regulatory bills I looked at from our government affairs team and would mark up when it said, make sure you're fair or you're without bias. What does that mean? What's the number? What's an approved measurement? And we still see it. The EU AI Act says high risk, and Colorado says consequential. We've taken a stab at putting in various application areas into those groups to say probably this, probably not that. Let's deal with it that way. I think ultimately this concept of assessing a risk level is only going to grow, and that will tell you a lot about how you deal with these and what's required. We had so what seemed like an ever increasing tool set of testing tools for bias and for disparate impact, and then would apply them based on the model we were looking at. And those were very solid tools. The application thereof was much more of an art than a science. And we wanted to get that more mechanized, and maybe in time it can. That said, the other things I think you can do to prepare for these right now, and there'll be more bills that come down the line, have dedicated teams that are scanning to look out for those. Keep updated. Here's the new regulations that have been proposed. Here's how it could impact you, which is a great help. The things we talked about with documentation, they're all going to ask for that. Get your data lineage and your data house in order, get the models documented.
Hope is not a strategy, but we can hope for some changes and some clarifications in the special session that Colorado is holding so that they can perhaps issue some clear terms and definitions that we can march towards. With that, I also want to note Colorado is not the only state with an AI law, and it is important to not just be looking for the new AI laws that are being promoted and considered, but the existing laws where states are issuing new guidance about how that law applies to AI and algorithmic discrimination. Examples: New Jersey, Massachusetts, Oregon, and more are likely to follow, just given the similarities of these laws across states. And it's not just happening in blue states. Texas passed a regulatory measure for AI. It had been cut back severely from what it was initially, but it is a red state with an AI regulation that no one saw coming.